circumstances can we actually say there's a class action in place or has been instituted, for example, and what are the challenges that are associated with a class action? In what cases can we say a particular matter is class action? These are the issues we want to interrogate on the program for this week, and I'm joined by someone who's brilliant enough to help us make sense of this discussion, but that will be right after the break. Stay with me. Thank you for staying with me on the program. I'm joined by Barrister Adaze Emata. Apparently, is a legal practitioner. Thank you for joining me on the program today.
Yeah, thank you. And a very good day to our viewers at home.
Okay, I want us to start with the issue of concepts. I know, yes, when people have need to go to court, of course, a case will be instituted, naturally.
Yes.
But when it becomes a class action, what exactly are we talking about?
Yeah, thank you so much for that question. I think the whole concept of class action is something that is a bit new to our own jurisprudence. And of course, it finds its origin in the American system, where, for certain actions that are classified torts, and torts are generally civil wrongs, involving maybe things like nuisance, maybe private nuisance, trespass, and what have you. So that it is our high court rules that have introduced this whole concept of class action. And class action is a representative kind of action. It is also called group litigation, where you find that you have a broad spectrum of individuals that are affected, by maybe a particular wrong, and it will be impossible for individuals to institute litigation. And of course, it will create some form of complexities, in the legal system. Administration of justice will always look for the easiest possible way a matter can be resolved. So when you have something affecting a group of individuals as a class, a very broad spectrum, as I said earlier, I think it is in such circumstances that class action is permissible.
You said that it finds its origins in the United States, for example.
Yes.
How much have we been able to, has it been able to find domestic traction, at least here in Nigeria, for example? Yeah,
thank you. Our High Court Civil Procedure Rules have incorporated this whole concept of class action. And I think, the way we have it here, it's somehow intermingled with this idea of representative action. And I think I'll quickly do a little draw a distinction between both. Representative action are normally actions that you can bring in respect of administration of estates. Like you find that a man has 20 children. It is not all the children that can bring an action, say in respect of the administration of his estate. So maybe 3 or 4 of them cannot bring an action on behalf of the group. Yes, maybe they have been named as the administrators, so they bring that action on behalf of the entire estate. I've handled a case like that before, where somebody's estate, it was just 3 of his children I brought in as the plaintiffs. Though we ended up in court because they didn't pay me what we agreed, So that's a different story for another day. But essentially, when we now talk of class action, we are talking of a very broad spectrum of individuals. Say the people who enjoy electricity in Edo State can bring an action against BEDC. So can that be said to be a class action? Yes, because it's a species of a representative action. And of course, our High Court Civil Procedure Rules have incorporated it into our body of laws. Though the Constitution is not clear on this issue of class action, but Section 6 sub-6 paragraph B of our Constitution talks about individuals going to court, as in the court has a jurisdiction to entertain certain matters involving individuals and governments, especially when it borders on their civil rights and obligations. So to that extent, the various high courts, like in Edo State, we have our High Court Civil Procedure Rules of 2018. Precisely, Order 13, Rule 15 provides for class actions. And it does not just stop there. It gives the categories of actions that, the subject matter for which such actions can be brought. First, administration of estate is one. Then 2, where you have this issue of trusts, as in matters relating to trusts. Somebody leaves behind a particular property and he appoints trustees. So for such matters, it comes within the purview of, either class or representative action, so that one of the beneficiaries can bring an action on behalf of the entire beneficiaries of that trust. Then, of course, we also have land under customary law, whether family or communal land. So such actions, of course, can be instituted by way of either a representative action or class action, because that particular rule combines it. It talks about representative or class action.
Right.
Then, of course, in interpretation of certain statutes, you can bring an action either as a class action or representative action where it involves the interpretation of not just the statute, it can also involve a written instrument, maybe a contract, but it's somewhat limited. So as we progress, I will now bring out a particular action where this whole concept of class action was well defined and codified in the state civil procedure rules.
You look at, for instance, some communities in the Niger Delta of Nigeria today, some of them going to courts, sometimes even beyond the shores of Nigeria, to seek redress over oil spill, all of the environmental degradation being done to them, and so on and so forth. Then you come to the market, for example. You see unions within the market also going to court over certain issues, including what they now call a double taxation or multiple taxation, and so on and so forth. From the brilliant point you've established so far, it appears this process can be a bit complicated, or at least complex.
Yeah, it can be, because over the years, we've always had this problem of course, it's a challenge within the legal system, the whole concept of local standard. And of course, the court can say, oh, we don't have jurisdiction on that core, because it goes to the very roots of the court's jurisdiction. If the subject matter is not within those subject matters that a court can handle. And that is why, if you look at, say, our Edo State High Court Civil Procedure Rules that provide for class action, it identifies those specific areas for which class action can be brought. The question is, for this market women example you give, I doubt if it does not involve the interpretation of a statute. But as I said earlier, a state took it further. When you look at the High Court Civil Procedure Rules of Cross River State, I have practiced in that jurisdiction, so I know a bit of what they have there. And I can tell you safely that when you look at all the various High Court Civil Procedure Rules, including that of the Federal High Court, it is only Cross River that has an extra a provision. And that provision has to do with actions for an injury that affects a class of individuals. And the law even took it further by saying that all residents of that state can bring an action for any form of injury, for as long as it's an individual injury affecting a class of individuals. Of course, any resident can bring that action. And again, it's very important that it is not something that is cast in stone. For you to bring a class action, especially representative action, you must get the consent of the persons within that area. And that is why
must be on the same page.
Of course, you must be on the same page, and that is why the procedure is a bit different from normal actions in courts. You will need the permission of the court. So you have to bring an ex parte application for the court to now appoint you, right, as the representative of that class. So that the court, having granted you that leave, that permission, it therefore means that you can bring that action. And whatever judgment the court will give at the end affects every individual in that particular group or class.
We've seen cases that have gone, stretched for years, 2, 3, 4, 5 years, even longer. And then right in the middle of it, the next thing you hear is, well, this court does not have jurisdiction. And then I'm thinking, to what extent does jurisdiction become a clog in the wheel of progress where class actions are concerned?
I think it has to do with you looking at, because for lawyers we do one thing before we bring an action in court. There are certain conditions precedent you must consider, namely the issue of jurisdiction, because it goes to the roots of every matter, because that is what confers the authority on the courts to look at a matter. The court cannot go ahead to give a judgment, and even if it does, on appeal, the issue of jurisdiction can be raised for the very first stand. So it is the authority for which a court can either deal with a matter or can sit as a court of, as they say, competent jurisdiction. I'll give you an example of the issue of jurisdiction. You talk of territorial jurisdiction. You cannot have a dispute in Edo State, then you go and file the matter in Delta State. The court in Delta does not have jurisdiction. Then, I actually earlier mentioned those areas for which a class action can be brought under our Edo State High Court Civil Procedure Rules. I listed there, administration of estates, matters involving trust, the issue of land, as it relates to, either community or family land. And I also mentioned the issue of interpretation of the statute. So once it does not come within this particular action you want to file, does not come within the purview of these items listed under 13 Rule 15 of the Edo State High Court Civil Procedure Rules, of course the court cannot have jurisdiction because the law has stated clearly the areas for which such an action can be brought.
Let's look at, I mean, you're a very brilliant and forward-looking lawyer. Does a lawyer really need to specialize, for example, to be able to, as it were, handle matters that have to do with class action?
I think our own jurisprudence is such that as a lawyer who has been called to the Nigerian bar as both an advocate and a solicitor of the Supreme Court, of course you can handle any matter. Right. But I think there are some lawyers that have devoted their time and energy to specific areas. Like in Edo State, for example, you find some lawyers who are very good in estate matters, right. Like maybe this issue of Igilbe. I had the principal, the late Alfred Ogobame SA, and he was a guru in that area. That popular Agidigbe's case, he handled it even up to the Supreme Court. So for such persons, yes, you can consult them. But I think every lawyer should be able to do a matter as far as, you know, he has one, the brilliance, and of course, is an established legal practitioner in that particular area.
We're just going to take a break quickly now, but when we return, I'll still be talking with Barrister Dazoye Emata on some other areas as far as the class action is concerned. Stay with us. Thank you for staying with me on the program. I just wanted to ask you this. I've talked with many lawyers in the last couple of years with regards to the legal and judicial systems in this country, and we always talk about some of the challenges as far as these systems are concerned. They say the wheel of justice turns slow. Some persons say it turns even slower in Nigeria. How does that impact class action?
I think I give you an example of what this whole idea of, you know, they say justice delayed is justice denied, right? And also they say justice rushed is justice crushed.
Right.
So it's both ways. But I think our biggest problem has to do with our High Court Civil Procedure Rules and our laws generally, because there has always been this problem of technicality.
Yeah.
And, you know, it also gives room for adjournment. You know, you see very minute points that could be resolved even in the judgment of the court. You now want to appeal and interlocutorily appeal. You have not even gotten into the substantive matter.
Yet.
So such matters, of course, can drag for years. But I think over the years, our legislature has put in certain inbuilt mechanism to check, like, I give you an example, election petitions, for example. You know, the law is now that there's a particular period within which such matters must be dealt with. You
cannot exceed that window.
You cannot exceed 180 days for election petitions.
Right.
And even the law has been amended to even include pre-election matters. Like, I give you an example, those matters involving maybe a candidate, you challenge a candidate's qualification. The fourth alteration of our constitution has now made it possible for such matters to have a time frame, so that such matters are not ad infinitum. So we are now even advocating that high courts, I mean the chief judges of the various states, should even introduce practice direction. You know, practice direction are additional rules or supplementary rules that the chief judge can make to reduce some of these technicalities.
Right.
You know, you create timelines within which such matters should be done. I don't see why such should not be extended to criminal matters and even land matters. We have some matters that have lasted for 18 to 20 years. Even at times the litigants have died. Even the counsel handling such matters die. Even the judge sitting over the matter dies. That way it also contributes to this issue of delay.
You know, I was just thinking, I mean, off the top of my head a while ago as we were talking, we've seen cases, real time cases, class actions taken outside the shores of Nigeria. And then you're wondering, what are the dynamics that inform such a move? For example, we're seeing judgments in class action matters coming from outside of Africa altogether.
Yes.
You want to give us a piece of education on that?
Okay, one is, I want
say oil companies
yes.
in the Niger Delta versus, say, a community somewhere in River State or
yes.
in Cross River or even in Edo or Delta State
yes.
or Bayelsa, having a matter that goes all the way to somewhere in Europe. A class action case, and they're wondering, couldn't we have been able to institute this matter, I mean, in Nigeria?
I think you have some of these oil companies having their main office, say in the place like Netherlands, so that individuals from such communities can bring up such matters in such courts, because the rules of those courts allow such actions. Like you talk of Shell, They just have an office in Nigeria. The main office of Shell, you have them scattered across the world, like Chevron in America, and I think Shell also have an office somewhere in the Netherlands. So you can actually bring an action in such a jurisdiction for as long as the rules of that particular jurisdiction allows you to bring such an action. Of course, that can be a forum for such suits, you know.
Okay, let's talk about...
Because those individuals are actually either citizens of that country or they are residents there. So in such a situation, they can bring such an action.
Like Shell being Dutch, for instance. You know? But let's talk about, you made reference to the possibility of maybe a judge over a class action matter dying, or sometimes even the council, for example, or the litigants themselves. Where you have such extreme circumstances, what is likely going to be the outcome?
I think in such a situation, because the process of now assigning the case to another judge, it's a long process. At times you find that, you know, they'll say, oh, you have this issue of missing files and what have you. But I know with the way things are done now, because now we now have the e-way of doing things, e-filing and the rest. So these things, of course, they are stored somewhere. So it will be easy for you to transmit these documents. I remember just recently the NSAS protest. You know, when the High Court building in Lagos was burnt, the registrar, the chief registrar and the chief judge came out to say, yes, much as these documents were burnt, we have soft copies of all documents that have been filed. They even encouraged, you know, litigants and their counsel to come with their own copies. So no matter what challenges you find within the system, there's always a way out. But coming back to this issue of the rules, I think there's need for states like Edo to bring theirs in line with what a state like Cross River has done by specifically stating that once there's an injury against a particular class of individuals, such an action could be brought, not essentially when it touches on maybe administration of estate and what have you. So I think there's need for our Edo State High Court civil procedural rules. The legal amplitude there should be expanded to include, you know, civil actions for wrongs affecting the class of individuals. Like as I said earlier, the Cross River State rule was very clear and specific.
And that's exemplary.
Yes, exemplary. That's the state in Nigeria that has, you know, that particular provision. You look at Order 13, Rule 13 of Lagos, nothing like that. It's actually an exact, you know, prototype of what we have in Edo. Same thing with Order 9, Rule 9 of Abuja. And it cuts across all the states, but it's only Cross River that has stood out as the avant-garde, and now clearly saying that, yes, class actions can be brought by residents of that state.
You know, when we look at a lot of class action matters that we see, it's always between communities and some of these multinationals or big companies that are very influential, have a lot of financial muscle and so on and so forth. Then sadly, ours is such that most of these communities are inhabited by poor, uneducated, or if you like, in some cases, illiterate people. All right, and some persons say, look, these companies are apparently profit-oriented, and as such, they crush whatever they land on. That has a serious implication, doesn't it?
It does. I'll give you an example. Though this was not a class action, I remember when the president appointed somebody from Edo, though this may sound curious, as NDDC chairman, and of course the law was clear, right? That it is a turn of Delta State because it was in an alphabetical order those appointments have been made.
So D has got to come before E.
Of course. So because of what we saw, a friend of mine in Delta and I, we took up that matter at the Federal High Court. We asked the court to interpret the provisions of Section 4 sub 2 of the NDDC Act. Of course, it was supposed to be a class action, but the question is how many of these persons can you encourage to maybe give you a fiat that yes, it is on your behalf we are doing this. Because we had this feeling that these people could be bought easily. And I can tell you that true to my fear, even the friend of mine from Delta who had engaged, at some point he was backtracking for political and obvious reasons. But I pursued this matter to a logical conclusion. Until the federal government now saw reasons with us and withdrew that particular nomination they made because it was not in line with the provisions of the law. So that was not a class action, but it was a form of public interest litigation that an individual filed. And by the time I filed that matter, I was the very first person to file that matter, you know, August last, I think towards the end of August into early September last year. But by the time I had gone far with that matter, I discovered that persons from different communities had filed their actions from all the states in the Niger Delta. So we have close to 18 cases in court. So I had to now move that such matter should be consolidated. So that is another way of achieving class action, because if these individuals from all these communities, the court now decides to grant an application to consolidate, it means that we have a common interest.
Right.
And that brings out the future of class actions. There must be a common interest. There must be a wrong against individuals within that particular community. Because once the interest cannot, as it were, be ascertained, of course you have a three-pronged test, and you find that across the various rules of court. First, what the court will do is to ask the first question. Where, for instance, the individuals within that group cannot be ascertained, or cannot be ascertained, the court will now ask the question. If they cannot be ascertained, can they be found? Once that question of yes, they cannot be found or they can be found is answered, the next question is, even if they can be ascertained or be found, is it not better that an individual or group of persons be allowed to bring this action on behalf of this particular group that can be ascertained or be found? And I think that is the third question that the court will normally consider. Much as we have this group of individuals who are Niger Deltans, yes, these people can be found within the 9 oil-producing states of the Niger Delta. But I think it is safer for a group of individuals, or maybe say 5 persons, bring this action on behalf of the entire people of Niger Delta. Because if we were to bring an action, when you look at the population of Niger Delta, we run into tens of millions. So it is only by way of class action such wrongs can be achieved. So I had to bring that application for consolidation. So imagine if we had taken up that decision as a group of individuals, as groups of individuals within the Niger Delta to bring a class action, it would have reduced the burden on the courts. And that was why the federal government was now constrained to withdraw that list, because it was already affecting the smooth administration of justice, especially at the level of the Federal High Court.
You see, from all you've said, it's very clear that the class action concept needs to find more penetration, needs to find more traction in this part of the world. But then again, you're wondering, what more do we need to do? Is it only a matter of practice direction, or are there some specific other things we must do? Because you have made continual reference to the Cross River State example.
Yes.
So what must we do more for other states like Edo, for instance, to also be able to get bitten into line and then be able to imbibe the culture of class action more than ever?
I think for us as a country, we've always had this challenge, and it is called corruption. The whole concept of class action is a very beautiful one, because you are looking at a public interest litigation that benefits everybody. But because you find that, like within the Niger Delta, you want to bring an action against Shell, you say you present a particular group of individuals. These companies, or even those in government, can go behind you to influence these individuals. And once some members of that class bring an application to say, no, we are not interested in this matter, it becomes a cog on the wheel of progress.
Right.
And you talk about the wheels of justice, or the windmill of justice, which grind slowly, but it can only be sure if there's some form of unanimity. So poverty has become one of the greatest bane of class action in Nigeria. Not just our rules. Yes, we have very beautiful rules, right? But again, the judges have a role to play, judicial activism. You don't just have this armchair approach to legal interpretation. I mean, there should be some form of flexibility. You don't just ride on technicalities, but you do substantive justice, right? Or substantial justice, as it were. So that, again, is one of the reasons why we think the judiciary should be well-funded. Because when they are well-funded, this issue of judicial activism will find its way, across, boards.
Okay, I think that's one very beautiful place to leave this discussion about class action. Thank you so much, Barrister.
Thank you so much for having me.
We do appreciate it. Okay, we'll leave the program at this point. We're back here next week, Monday. Our coverage on ITV continues. Enjoy the rest of your day.